Hello, everybody. I'm saying hello, everybody, but I cannot see you. But welcome to this book launch from members of our chambers, Charlotte Hadfield and Alice de Coverley, the practical guide to the law in relation to school exclusions. Thank you all for joining us. It is a shame that we live in times where we cannot have this launch with a glass of champagne and something nice to taste in our hands. Those are the book launches that I'm certainly used to, but do not fret. This evening, for this very short period that you have us, there will be plenty of sparkle. It shall come not from myself, but from the authors. My name's Lachlan Wilson. I used to head up the education law team in Chambers here at 3PB Barristers. It didn't take long for younger, better and more capable minds to steer that ship. And two of them are with us today, and two of them have proven their prowess in the work that they are launching today. Charlotte Hadfield, described as an exceptional barrister in the area of SEN law. Her expertise means that she's able to secure positive outcomes for young people and their families, which change their lives for the better. The same accolade also goes on to say she is an excellent advocate, and I will remind her of that in case her book writing success takes her off into other ventures and she fears she wants to leave her day job. She shouldn't, because she's brilliant. Alice de Coverley, very knowledgeable and passionate. She really helps her clients to understand what the issues are and identifies the legal risks and next steps. She's very approachable, very supportive to parents, very calm and collected in a stressful environment. She is also a former pupil of mine, but like so many things, certainly the pupil overtakes the master in her brilliance and her ability, especially in this field. I also want to give a little shout out for those that were called upon to provide the foreword to this book. Tony and Stephanie Mullally from the Hillingdon Autistic Care and Support charity that does wonderful things. They have said some lovely words about the book in the foreword, but I just want to quote them. They obviously, in their roles, provide excellent advice to parents with children with special needs, but they say whilst we're able to give correct advice to parents, it would have been advantageous to signpost this parent to a publication like this book, which has been written with parents, caregivers, educators, and advice and guidance workers in mind. This book is an easy read, whilst outlining all you need to know in relation to exclusions and ensuring schools have followed the process in a lawful manner. All praise to the authors for this easy to read publication, which I would strongly advise any parent to purchase for their SEN toolkit. That's all I propose to say by way of opening. Can I encourage all of you to use the Q&A button that you see below you, beneath the screen, to ask any questions that you would like to ask. You might confuse it and accidentally press the chat group. I know that many of you who are attending today know both Alice and Charlotte, and you don't no doubt want to pass on your good wishes to them personally. By all means, use the chat function for that. But if you want a particular question to be asked of the brain boxes that appear before you today, then please use the Q&A button, and I will try and pick them up, and I will do my level best to try and get them answered by our two authors. I'm going to kick off. By really addressing both Charlotte and Alice, but we'll ask Charlotte this question first. All right, why does the field of exclusion need an easy read at this particular time? What do we need a new book on exclusions for, Charlotte?
Well, there hasn't been a book exclusively on exclusions for a while. I think the last one was written in like the early 2000s. The rules have changed a fair bit over that time. And even back in the 2000s, school exclusions is a sort of funny area because it generally gets a chapter in a practitioner's manual. So if you read a sort of bigger manual about education law, you'll find a chapter in it. There are some websites out there that are absolutely brilliant for exclusions, and we've referenced some of them. We've got a little list in the back of the book. So I'm probably going to miss people and kick myself for it, but IPSI, SOS SEN, Special Educational Needs Jungle, and then there are brilliant charities like Sunshine Support, HACS, of course, our wonderful friends at HACS, and they all have great resources on school exclusions as well, obviously with a certain amount of emphasis depending on whether their emphasis is special educational needs or children from particular socioeconomic backgrounds or whatever. But I think we felt, and our publishers at Law Briefs also felt, that it's one of those areas that you probably couldn't make a huge textbook out of it, but at the same time there's definitely more than just a short chapter in it. And so that's what we tried to do here, just to produce a kind of one-stop shop that covers all of the different areas where exclusion rears its head. So we tried to look not just at the statutory scheme, which obviously we all know about, but we've included something on behaviour and discipline, because I think a lot of parents and perhaps schools don't necessarily know the full legal remit of that. So we've included that to give a kind of background. So that's I think where we were going, wasn't it, Alice?
Yes, and I think what was really interesting about the book is that I think we estimated that we would write a 50-page book at the start of it, and then it turned out to be about, I think, 200 odd pages, 215, because we realized how complex it is according to what school the child is at and what age the child is at, whether they're sort of in sixth form, whether they're in a grammar school, whether they're in an independent school. There's also different scenarios to meet those different types of issues that might come up in those settings. So we hope it's helpful because it will span all types of exclusions and all types of settings, whether you're 5 years old or 18, and whether you're in a maintained special school or a independent mainstream school, whatever setting you're in. We wanted it to be able to help teachers, head teachers in those sorts of settings, and also young people and parents who are in those or no longer in those settings, depending on what the issues are in that case. So I think that I hope that it would be helpful in that regard, because we haven't really seen things that focus on exclusions across the board. There are things that I focus on exclusion in the maintained sector, and they are incredible, and things that I focus on exclusion in the independent sector, but not necessarily things that cover everything all at once. So this is what we hope to do in a kind of really comprehensive guide in one place.
Well, now you begin the book with a superb quotation from an 1865 case that refers to these types of decisions not to be undertaken wantonly and capriciously, which could almost have come out of the King James edition of the Bible. But tell me this, what were the burning issues surrounding exclusion decisions that made you want to leave the day job to one side and get this publication out? Charlotte first.
Why did I want to? So why am I interested? Is that the question?
And also, what are the particular exclusion issues that fire you up? What's going on that means that this book is needed?
It's interesting, actually, because I come at that from two different perspectives, I think. So firstly, I do a lot of work with children who have special educational needs, and unfortunately that also includes that includes sort of first tier tribunal work and judicial review work and discrimination work, unfortunately, also because we find both in independent schools and in maintained schools, sort of mainstream schools, that actually we know this from the statistics, don't we? Those children are at far increased risk of permanent exclusion compared to children who are developing neurotypically. So it was partly that I did a number of discrimination cases representing parents or their children with special educational needs and disability. And I think it's also, funnily enough, doing those cases from the perspective of representing schools, because actually those schools, those cases can be immensely complicated for schools. And I think it's very easy for people on either side to become entrenched. So I think that that parents in these circumstances, I think it's difficult to fault them for it, in the sense that having your child, having the experience of your child being excluded from school with or without something like a disability in the background is going to be incredibly painful and upsetting for parents. It's I think it's probably one of the most difficult experiences that a parent could go through. And I think that the parent very quickly gets into a mindset of, the school just wants my child out. And of course, in a sense, that's not 100% inaccurate, because of course the child has been permanently excluded. But working on those cases from the school side, you also see how difficult those decisions are for the school. They've got to take into account an awful lot of different considerations. There are a lot of different agencies who need to be consulted. What's available, certainly from the state perspective, what's available in terms of services varies massively from borough to borough, or from council to council, but also from the independent side. You have independent schools that are part of gigantic trusts or charities, and they're very, very able to sort of manage an exclusion process. But you also have a number of independent schools that are, they're independent, they're small, they might be one of a trust that's got maybe another couple of schools in it, and those schools find these processes very hard. So I think from both ends, we certainly, and I think Alice as well, we just wanted to give people something that, this will give you an overview of what you need to be thinking about in this situation. It won't answer every single question that you have, and there will always be factual scenarios that are really unusual and would have anybody scratching their heads and saying, well, I can't find an answer to this in a book, what am I supposed to do? But we hope that this book is going to give people that broad overview and sense of what's appropriate and what they should be looking for.
Thank you. Alice, is there anything that from your practice dealing with exclusions, was there anything particular that fired you up and wanted you to contribute to this book?
I'm not sure. Yes, it was from my practice, but I think it extends far further back for me. So I dedicated this book to my little brother, Redmond, because he was forever in the head teacher's office at school. And whilst he wasn't necessarily officially permanently excluded, we could probably characterise it now slightly differently under other language used by Ofsted in terms of off-rolling. But I was very aware, even though that was the 90s then, and I was very aware of how he was treated, and that's really fired me up in terms of why I do this job at the moment, and want to make sure that all young people don't go through that same sort of misunderstanding about a child's needs and, who they are as a person and wanting them to flourish in a school, which he did eventually do, and now he's wonderful and flourishing massively where he is. But that's sort of the main reason why I really feel passionately about school exclusions. But the second reason was in at law school. When I was at City Law School, I started working on the School Exclusion project with Sarah Hannett, and we then she was the running that, and I was the student director of it, and I worked on that project alongside various other notable young junior names at the education bar. Mark Greaves, my wife Rosie Bailey, we also worked on it together. Rahana Popal was another character in that mix, and we worked really hard together to try and make school exclusions something that young people could they could access our help to become advocates as students, to help them in independent review panel hearings and governors' hearings. And we did find as students that it was still very difficult as a process to navigate, even though it was, quite a lot of the time governors' hearings are held in school libraries and so on. And it came down to schools not necessarily understanding their legal obligations, but also parents not necessarily understanding what the school's limits might be in terms of what they can do to support young people in that type of setting. And so for me, that gave me a really useful insight before I really trained as a proper lawyer at the bar, to be able to see what kind of barriers there might be and what kind of advice we would want to give to schools and to practitioners and to teachers and parents about what they might need to try and make sure that exclusions were done properly and lawfully. So that's why. So it kind of goes back way before I think I became one of your pupils, Lachlan.
Brilliant, Alice. Before I ask the next question to you both, I just want to put a shout out now to members of our audience. I want to encourage them not to be shy, but to use the Q&A button that they should see at the bottom of their screens. We are having some lovely comments in the chat session, in the chat facility, but to use the Q&A facility to ask any questions of our authors, this is your opportunity to speak to the authors. Sadly, this is not an opportunity to get a signed copy, but I'm sure, should you write in with your purchased copy, no doubt both Alice and Charlotte will get together at some stage and sign one for you and have one sent to you. I also ought to just draw everyone's attention to the discount code. For those of you that have joined us this evening, as I say, thank you for joining us. And the thank you comes in some form of prize, which is you will have the opportunity to take the benefit of a discount code that will be published in the chat facility. So do take, for those of you that have already bought the book, I do apologise, you haven't had the benefit of that discount code, but we do thank you for that and for supporting Charlotte and Alice, and we hope you will also feel supported by the content of the book. But for those of you that haven't, there it is, there's a discount code for you. What I want to ask next really follows on actually from what Alice was just saying about the benefits of the of the book for parents and schools alike. And I wanted to ask you, Charlotte, because I know we have discussed this, that you specifically did not want to come at the issue from one angle, i.e. to be some kind of Bible for schools to get it right, or from the other angle as to be some kind of checklist for parents to attack schools. Perhaps you could say a little bit more about that, about the angle that you specifically, or the non-angle that you specifically were very keen to avoid.
Yeah, it's a really interesting process actually, writing the book, because when you're writing submissions or pleading something, or you know, sort of trying to make a case, you don't particularly worry about appearing partisan, because that's the job. But with the book, I did find myself when I was writing, and I don't know if Alice had this as well, you'd sort of look back over something and think, well, I'm going to change that because that looks as though I am being very critical in respect of schools, or that looks as though I am being very dismissive of something that I know that parents would be anxious about. And I think the reason for that is that ultimately everybody, the big thing that I've taken away from my work in exclusions is that everybody wants to get the answer right. And everybody's understanding of what that answer might be differs, but nobody who I have worked with on the school side takes the decision to permanently exclude lightly. They may have very strong feelings about it. So, for example, certainly if you've got a situation where staff or pupils in a school have been put at risk as a result of dangerous behaviour. Now, my greyhound is just about to enter the book launch.
Excellent.
Would it be complete without Jasper, who sat here and farted gently, deep into the night as I desperately tried to meet publishing deadlines. So, you know, let's not forget the contribution of this guy, because he's been amazing all the way through. Yeah, I think I was saying that my experience is that everybody wants to get the answer right. Parents want to get the answer right. And that's the other thing that I've taken away from my work, which is that I think that there can sometimes be, I talked about the perception by parents that schools just want the child out because the child is too much trouble and they don't want to think about it anymore. I think sometimes there can be a perception on the school side that the parent doesn't really understand that the child could sometimes be difficult in school. And my experience is that's really not true. Most of the parents that I have represented have been very aware that the child's behaviour has been poor, or they have been very aware that the child might, perhaps when you're talking about a child with disabilities, they understand that managing those disabilities might be a challenge in a school setting. And so I really wanted to make sure when I was writing my parts of the book that I was really helping everybody I wanted to help. So I didn't want to walk away feeling, oh, well, I've written a book that's for parents, or I've written a book that's for schools, or I've written a book that's for local authorities. I really wanted, and Alice and I talked a lot about this, we both really wanted to write a book that would help everybody who was involved in the exclusions process for that reason.
Thank you. Alice, is there anything you wanted to add on that specific point? Otherwise, we've got a couple of interesting questions that have come through the Q&A, and I'll move straight to that, but give you the opportunity.
No, I think we do actually have some really good questions that have just come in, so I'm happy to go on to those actually.
Let's go. Right, well, our first question that came in from Yvonne, thank you, Yvonne. Following on from your research, both of you, what are the top 3 things you would change about the current DfE exclusions guidance? And I know you're burning to answer that question, Alice, so let's hear from you first.
Well, I think that there was some really amazing research that I referenced in the introduction, which is about the Justice Working Party, and they made some recommendations that were pretty comprehensive and they described them as pretty radical, but they were quite interesting at addressing some weaknesses identified in the School Exclusion guidance, and they talked about introducing a new role of a specialist independent reviewer to conduct an investigative review into individual exclusion decisions, which might help at sort of replacing the first stage review currently being conducted by the governing board of the school. And I think that they're looking at their recommendation of sort of specialists with decent training on school exclusion and understanding what those powers are, proper consideration of unmet needs, those sorts of things are things that I agree with in their recommendations, but also I think that I would like to see sort of more across the board. So that in reality would mean better training for governors, mandatory training even on this matter as part of sort of general safeguarding training. And recognising, I would say probably related to that, the second thing I would say that I would recommend is recognising exclusion as a safeguarding issue. So much of, I spent the day today in the independent inquiry into child sex abuse, and a couple of the questions today of Nick Gibb MP and Baroness Berridge were about off-rolling as a safeguarding issue, and making sure that schools obviously don't off-roll illegally, and have proper processes in place to secure welfare of young people who are at risk of exclusion, because there's links between that and child sexual exploitation. So for me, it's seeing exclusion as a safeguarding issue is probably the other thing that I would want to see better recognised, I think. I don't know. What do you think, Charlotte?
Yeah, I think that's right. In terms of my top 3 things that I would change, I have 3. They're slightly less interesting, I think, than yours, Alice, but they're a bit more in terms of the procedure, in terms of exclusions procedure. So in terms of the top 3 things that I'd make clearer, I think firstly, I think everybody could do with some clear guidance on what happens when there has been a really serious incident, or what looks like a really serious incident, but the investigation can't be concluded in one day. So, you know, what happens in terms of whether or not the child who is suspected to have committed a disciplinary breach, you know, do they stay in school? Do you exclude them on a sort of on an interim basis? The guidance, it really fudges that, doesn't it, Alice? And it's you know, I mean, that was one of the bits that I think we found quite difficult in the book, because it's very hard to know exactly what advice to give to people in that situation.
Yeah, no.
Go on.
No, I completely agree, and I think that something comes up quite a lot is, what do we do in those circumstances? Because you need to take immediate action, but then also need to investigate properly. So it can be very tricky.
Yeah, so, and genuine safeguarding concerns, which I think can be really hard to manage for everybody. And I think the concern also is, if you keep the child in school in those circumstances, there's obviously the concern about because even excluding on an interim basis, if you're going to bring them back, would be very traumatic, I think, for that child. So it's not a decision to be taken lightly. But at the same time, potentially, are you setting the child up to fail in some obscure way if the child is in school while the investigation's going on? I think that's really, really hard. So we could do some more guidance on that. The second thing is, there's very little guidance about how head teachers should carry out their investigations. And I think there should be a bit more, it would really only be along natural justice lines, but I still think there could be more guidance on how to do that. And the third thing is a bit more express guidance for independent review panels on how to deal with issues of discrimination and exclusion. So those are the 3 things that I think I would want to beef up in the guidance.
Yeah. Definitely. In fact, a fantastic question from Yvonne there. So thank you for that. Dare I suggest it presents possible material for a new book, whether by yourselves or possibly even something that Yvonne could contribute to as well. We've got a second question from Claire Jackson that asks your opinion on the recent case of RD and GD and the proprietor of Horizon Primary. I'm going to filter that one, not because I don't doubt that you've got views, but actually because it's not always easy to comment on recent cases unless practitioners have actually read the case immediately prior to answering the question. However, the question from Claire then goes on with a comment, and I know, Charlotte, you would almost certainly wish to contribute to the comment. The upper tribunal stated that a breach of a legal duty, such as a failure to use best endeavours and or secure a full-time education, would be properly pursued using judicial review and not through a claim of disability discrimination. And in that, the upper tribunal criticised the previous decision of Hampton Dean on that point and declined to follow its reasoning. So the comment is worthy perhaps of any opinion that either of you might have, but we'll start with you first, Charlotte. Can we agree with that? That if there's a breach of a legal duty, such as a failure to use best endeavours and or secure full-time education, rather than see reinstatement potential through a disability discrimination claim, judicial review should be the proper route. Do we have any feelings on that? Certainly Claire seems to think it limits the avenues open to parents as far as remedies and where they pursue their remedy. But what do we feel, Charlotte?
I do have some views on that, and actually in terms of the reduced timetables point, I have a very brief view on that, which I'll express, which is that I think it's difficult to take any sort of broader messages from the case because disability discrimination claims are always so very sort of dictated by the circumstances of the individual child and how their disability affects them. In terms of using judicial review rather than disability discrimination, I don't know what Alice thinks. I have to say I disagree with that. I agree with Claire that really limits the kind of remedies that you could seek. I think there are a couple of points that I'd make about that. The first is that judicial review is a brilliant mechanism for securing a remedy where there is no other remedy available, where there is no other avenue to remedy available. And we all know, sort of in broad terms, the case law on that. But judicial review and disability discrimination claims are very, very different mechanisms. Judicial reviews are generally decided on the papers. You only get permission to bring a claim for judicial review if you don't have an alternative remedy. And so, frankly, my immediate reaction is if you rock up to the administrative court and say, "Give me leave, please," and you know the papers are peppered with descriptions of the child's the child's disability, the other side is very likely to at least start by saying, "Well, you shouldn't give leave because this child's got a remedy in the first tier tribunal or possibly in the county court." So that's my first point. I don't agree with that reasoning. The second point that I think I would make is that judicial review is not about fact-finding primarily. It can be in some circumstances. If you've got a human rights element, for example, it could be. But it's not the remedy that I would pick for a disability discrimination claim, because a lot of the time you're looking for the tribunal to make a decision about what actually happened. And that really, you're looking for the tribunal to get into the facts and work out what happened. And in judicial review, the scope for that is just very limited. And of course, in terms of remedies, 9 times out of 10, not always, but 9 times out of 10 in a JR, you would really struggle to get a judge to order reinstatement. It would be very, very difficult, if even possible. 9 times out of 10, it's going to be remitted back to the decision maker for a new decision. And so, whereas in discrimination claims, as we know, there's much more scope for, there's more scope for reinstatement. There's more scope for a whole load of non-monetary findings, although obviously the FTT doesn't do very well in the field of financial compensation.
Yes, and it might be said, mightn't it, Charlotte, that reinstatement decisions are best left to the expert tribunal, the expert education tribunal.
Very much so, yeah.
Which would make judicial review much more unlikely, because of course they're not the expert in that field. They would defer to the expertise of that field. Alice, do you have any views on the this issue?
On the case itself, on RD and GD, anyone who is really interested in discriminatory exclusions should look at it, because it has some very useful discussion about multiple causes under section 15. So that's when somebody is treated unfavorably because of something arising in consequence of a disability. And what's quite useful is it sets out case law from the Employment Appeal Tribunal, which we often do have to import into education cases, and it makes it quite clear that the effects of the condition don't need to be the primary reason for the unfavourable treatment complained of, and talks about the case of Urso in that respect. So it's quite useful in itself. They didn't actually end up winning the case on that, and actually the outcome of the case ended up being the same. But if you are interested in the kind of that sort of aspect of discrimination, there is a useful précis of other cases in the section 15 world from the employment sphere as applied to this part-time timetable case. So I would definitely take a read of it. And it also, quite annoyingly, is one of these cases came out in November this year. Of course, we'd already published the book, so we'll always find that there's always going to be further cases that will interrupt things. And it had been nicely on pause during COVID. And then we were like, right, we can publish now. And then, of course, this case came out, but it hasn't changed things materially. And we do in the book, use employment law principles in the discrimination chapter, because they do have some neat application there. But yeah, no, I would certainly recommend having a read of it, because it's a very useful case about best endeavours and full-time education, and as well as about reasonable adjustments and section 15 cases. So
can I just coming back on that really quickly, Lachlan? I think I just had a quick look, so I just wanted to remember what was said particularly about the best endeavours duty. I think there is a kind of interesting sort of intersection between the best endeavours duty under the that schools have under the Children and Families Act and section 15. And to some extent, I guess it might be it may be that we never really see the pleadings in these things, do we? So it might be that it's just the upper tribunal commenting on how it thinks the case could have been put. I mean, you could bring a judicial review in respect of a failure to use reasonable endeavours under the Children and Families Act. It would be difficult because best endeavours is a bit of a woolly, in some respects, a bit of a woolly concept, but you could. And you could obviously also bring a judicial review under section 19 of the Education Act. So it's not that those aren't perfectly valid separate remedies. It's more that if you have a viable disability discrimination claim or a disability discrimination claims, it would probably be if you were invoking either of those sections. Really, I think in many circumstances, you might well say to yourself, well, if I want to do a lot of fact finding here and I want a good choice of remedies, I really want this to be an Equality Act claim. I don't want it to be a judicial review.
Okay, now questions are coming thick and fast now, so I'm going to encourage brevity in answers. There's two questions about managed moves. So the first one is, what are the author's views on managed moves, or rather that's the second one. So just bear in mind your views on managed moves, but perhaps also you can help answer Tracy Eldridge-Henmer's question. Local authorities are apparently advising that if a managed move is unsuccessful, the home school can permanently exclude for the behaviour incident that occurred before the managed move. And Tracy is saying she'd always understood that this was not permitted and schools could not permanently exclude for something that happened some time ago. I confess that's not my understanding, but Charlotte, perhaps you might have something to say about that.
Well, this is really interesting, because one of the things that I think we both like about the book is that it does contain, I would say, as much analysis as can feasibly be done of how managed moves work at the moment. So managed moves are a real oddity because they rely almost, in practical terms, they rely entirely on local cooperation. So the school that is considering whether or not to exclude has to decide that a managed move is appropriate potentially in those circumstances. They then have to try and find somewhere to manage move. I'm going to verb it. I'm going to verb manage move. So they then have to find somewhere to manage move the child to. And that could be, it might be very difficult to find another local school that is prepared to take that child on a managed move. And I am also aware from the work that I do with schools that this is a really finely balanced decision, because in a tribunal setting on a disability discrimination claim, and also actually before an IRP, they will always say, didn't you think about a managed move? And actually, the feedback that I get from schools is, we can't just phone up other schools every 5 minutes and say, will you take this child on a managed move? Because if we do, the other schools will not trust us to know when a managed move is appropriate. So that's a really interesting consideration that tells you something about how delicate these negotiations are. Because the risk for that teacher is, I need to be sure that the child I'm putting forward for a managed move is right for a managed move, because otherwise I will lose credibility and I will not be able to get children into managed moves when they really need one. The other thing that schools often don't think about, in my experience, is if you can't manage move to another school, you might be able to manage move to alternative provision. And that's something that they often don't necessarily immediately realise. So and the other thing to bear in mind is local authorities will always have a local policy on how managed moves should work. Most schools and academy trusts now will have a section on it in their behaviour policy. So there are all those policies to have a look at as well. And it's a really interesting and complex set of circumstances. Now, the answer to the question, what happens if the managed move fails? The actual answer is nobody really knows, because that has not been tested anywhere. And we have absolutely no authority at the moment. I keep and I know I'm looking at the audience and I can identify a few solicitors. We're desperate for a managed moves case. We are desperate for a managed moves case that will get us to a point where we can get some law on this, because at the moment, some schools will permanently exclude if the managed move fails for the previous incident. My own view is it's always going to depend on the circumstances. I think that if you say to my personal view is it's not right to say to a child, and if the managed move fails for any reason, you will be permanently excluded. My concern would be that you're fettering your discretion if you do that. I think you certainly should warn the child it is possible. If that is something that you would do. I have seen schools that will take children back after managed moves if they fail, and sometimes that works out and sometimes it doesn't. So the accurate answer to this, I think, I don't know about you, Alice, I think the answer is we actually kind of don't know. But a lot of people think you can exclude for the index offence, if you like, if the move doesn't work out, and a lot of schools do exclude for it.
Yeah, that's my experience as well. So there's a conditional managed move. I mean, I have to say, my experience in the last couple of years is that managed moves have worked quite well when you're moving from one academy to another academy in the same trust, because the kind of knowledge and understanding of that child goes with that. And it can be an effective tool, I have to say. Oh, did I cut out? I was just talking about multi-academy trusts being, because there are so many more of them now, where you do have exclusions or managed moves in that context, you can move to another academy where you are known at least by the governors or the proprietors of the academies and so on. So it does help a little bit in terms of oversight of that young person.
In both of your experiences, are schools, are local authorities putting time limits on the move to determine whether or not it's successful or unsuccessful, go back to the index incident? And if so, what sort of time limits are they imposing?
I don't know about you. How long have you had? I've had sort of 10-week.
3 months.
I think 3 months.
About a term, basically.
Sort of trial period, like. I mean, I think I probably would add that the Equality Act doesn't cease simply because they're in a managed move. So you can continue to use and think about the application of that in that period. And there's lots of useful case law on trial periods and making sure that that person has, you know, the support around them to succeed in that sort of setup. In my experience, it's no more than about 3 months that they have. But I don't know, it might be that it's within that justice report that I referenced or in the Timpson review stuff, the success rates of managed moves. But I can't say that there has been any detailed analysis of it. I'd be really interested if anyone's got any intel on that. But I don't think there's been any detailed analysis of the effectiveness of managed moves. I mean, obviously, the argument usually is that they're a better alternative to permanent exclusion, which is probably, for the most part, right. But I don't know if we actually have that level of analysis available to us from the Department of Education.
I don't think there is. I mean, the thing that I would say is I think I would be, so I don't think I would go as far, in answer to Tracy's question, I would not go as far as to say schools can't permanently exclude for something that happened a long time ago. I think, well, a long time ago is obviously a different question, but if you're at a point where you are you are considering permanently excluding somebody for something very serious, and there is something in the circumstances that makes you think one last chance. And I think I can see that it is unattractive to say to a school, you give a child one last chance, that one last chance does not work out, and there aren't really any mitigating circumstances in why it doesn't work out. So if you have a child who is persistently disruptive, there isn't really any kind of underlying issue that anyone can see. And of course, we have to bear in mind, I mean, obviously now, because of the DfE guidance, rightly, if you have persistent disruptive behaviour, your immediate thought is what's going on underneath. But there might not be anything going on underneath, or nothing going on that you can identify. And if that child, on the face of it, understands what the behaviour standards are, understands that they are being given a last chance, and they go to the other school and they behave in the same very serious or extremely disruptive way, I can see that if you ended up in a sort of JR or disability, I keep saying disability discrimination, but if you ended up in a JR or discrimination claim situation, I can perfectly see the tribunal going, well, you know, what's the issue here? On the other hand, if you have a child who's got some sort of really compelling mitigating circumstance, like a recent bereavement, trauma at home, a disability, something like that, you move them to the school and it doesn't work out because the school that they're moving to isn't able to manage their disability appropriately, or isn't able to give them the support that they need if it's something like a bereavement or family illness or something like that. I would struggle in principle to see how it would be fair for them to be excluded for the index offence because the school that's taken them, the transferee, isn't able to give them the support that they need. So I think it's really nuanced, and I don't think that anybody, I think in most cases where a managed move is appropriate, there are going to be circumstances in the background that make it inappropriate to say, and if this doesn't work out, that's the end of it, you're excluded. But I think there may well be circumstances where you can say, look, this is your last chance. There is a really high possibility that you will be excluded. But it's very difficult, and I would love there to be a case about it.
Yeah,
I really would.
The only case that is, there is one case that is out there that we talk about, which is a Welsh case where the offer of a managed move isn't properly made to parents and it's not explained properly to them. I mean, it may be because it was impossible to explain it because of all the reasons we've just talked about. But it wasn't properly offered to the parent, and therefore that was actually a JR, and then it failed on a kind of proportionality ground because it wasn't properly explained to that parent, so they couldn't make an informed choice about whether to take it, even though actually the threat of managed move, of course, should never be used as an alternative to exclusion. But it's worth highlighting there is that new case. There is one case, I suppose, on managed moves that we can use. But yes, let's make more case law, please.
Absolutely. Go on, Alice. I know you're burning to answer the question on your views on the Timpson review. So the floor is yours.
Well, I thought that it was a very groundbreaking and very important piece of work that was done by Ed Timpson. So he did it, for anyone who doesn't know, he did a big piece of work on school exclusion and reform to the whole process in 2018, and report was produced in 2019. But one of the key things, it wasn't just about reforming the process and making it easier or clearer, or training for schools being better and that sort of thing. It was also looking at exclusion from multiple intersectional angles. So one of the key sort of things that came out was, for example, if you're a disabled Black boy from a disadvantaged family with an education healthcare plan, you're 58% more likely to receive a fixed term exclusion than others in their secondary school career. So it was really key at highlighting rather deeper levels of inequality in education experienced by Black and minority ethnic children, by disabled children, by children on free school meals, by children who are in care. It really did try to tackle those sorts of issues. And we know that the school exclusion guidance does say that there are groups that are at disproportionately high risk of exclusion, and it says that. But the Timpson review went further at saying it by actually analysing the statistics, which do come out sort of on a periodic basis from the DfE. And it is really important to continue to look at those stats to see that why are there a higher proportion of exclusions for children who are from particular backgrounds or with particular difficulties. And so I think the difficulty is that that really important piece of work that was done by Timpson hasn't really gone anywhere. We've sort of been told, and we're told repeatedly, that children with SEND are more likely to be excluded. Children from particular ethnic backgrounds are more likely to be excluded. Yet sort of it's quite difficult to say what has actually changed as a consequence of knowing that to be the case. And there are various campaign groups that do continue to say this and call for change in the sector. So from my perspective, it's a shame that there has been no reform of the sector in light of that, and that the school exclusion guidance hasn't been amended to reflect those findings. But you know, the DfE has been busy in the last couple of years, particularly this year. So I understand it, but I still think there's more work to be done to address those sort of intersectional issues of exclusion.
Sure. Okay, there's a couple of questions that link exclusion and special needs, and we are all familiar with that being ever too frequent a link. And I wonder if both of you could comment on these. The first question really regards you to, asks you to comment on SEND and exclusion. Some schools feel they have no option to exclude to ensure the safety of the pupil. Others, because of behaviours linked to the special educational needs, and emergency reviews can take too long to organise. And linked to this question is another question from Ian Roberts, wondering whether or not actually schools would be better off providing training in certainly special needs such as dyspraxia and dyslexia. Might that assist? Because of course people suffering from not just in fact those needs almost certainly give rise to behavioural issues as well. I wonder if either of you could comment on that. Alice, you seem to be nodding more, so I'm going to go to you first on this occasion, if that's okay.
Yeah, I mean, so much of what is in the Equality Act in particular is about taking proactive action to prevent discriminatory conduct, and so that's sort of enshrined in the duty to make reasonable adjustments. So yes, so absolutely, having that sort of training in place from the outset is going to be really helpful. But recognising where poor behaviour or outbursts might be because of unmet needs, that's going to be really central. But also bear in mind that the first tier tribunal has a possibility in its remedies list to order schools to do training as well, because I think that in certain cases schools will recognise that they have not done very well in that respect, and the training may help to remedy that issue in a school setting. So yeah, so I think training is always going to be very useful, but training is only as good as the actual implementation and practice on the ground as well. So you can have the best training in the world, the best policies and practices in the world, but it has to, of course, show that impact has to be shown on the ground as well in the school.
Thank you. Charlotte, did you have anything you wanted to add to that, or shall I move on to the next couple of questions, which are very much procedural questions, but they've raised my eyebrow, so I'm wondering if we can move on to that.
So I just really quickly, in answer to the question about schools feeling that they have no option to exclude, I think those cases are very difficult. So I have seen some cases where both the school and the parents are very aware that the child has actually the child's needs cannot be met where they are. So I've seen children who really should be in special schools, where both parents and schools agree that they should be in a special school, who have been put in a mainstream school. Perhaps there's an EHC plan naming that mainstream school. And there have been some very sad cases where those children have ended up being excluded for behavioural issues, very serious incidents. Simply because for one reason or another it wasn't possible to amend the EHC plan. And in some of those cases the exclusions have been found to be justified in the context of the discrimination legislation, because the school was in a situation where they could no longer keep staff and students safe. I think the really difficult cases, I mean, there's always the possibility of a managed move to alternative provision, although alternative provision query whether that's going to be a great environment for many children who have special educational needs. But I think in those cases, sometimes it's been found to be justified that the move had to take place, sometimes it hasn't. The tricky cases there are where you have children with conditions like ASD or ADHD, where they do sort of understand what the behaviour standards are. So it's not that situation where the tribunal can just say this child does not have any understanding of what they're doing, but at the same time we know that those conditions really affect their ability to comply with behaviour standards even if they understand it. So it's a conundrum that hasn't been solved. There are cases like that. Whether the exclusion is justified is going to depend on the facts and the procedure adopted. But I agree, it's a real problem. It is a real problem.
I think in those circumstances, I often argue, if I'm arguing for parents, I say, well, the school, there might be steps that the school could take that they're not immediately thinking of. So, you know, consulting with the local authority, consulting with that child's experts in order to work out how to amend the school environment, that sort of thing. It's not always, whilst there are sometimes cases where there is really nothing more that can be done. In my experience, there usually is something that could be done.
Yeah,
and it's often really important the school works out what that step could be and exhaust that step before they then decide to exclude.
Totally. A lot of the problem in those cases, I've had the same thing representing parents, and a lot of the time what the school says is, well, we knew, effectively the school will say, well, we knew the local authority wouldn't be able to help, so we didn't ask.
Yeah, I can see that, and I understand that sometimes that can be the case, but sometimes
that's not going to be a good enough answer.
No, I agree with that.
Okay, we've got a couple of questions that I'm going to make links, and it's about really the evidence before the exclusion hearings. Firstly, a question from, I believe it's Nigel, or it's NPU. Hello, Nigel. Why do schools never disclose the names of the children making the statements of complaint? So there's obviously a procedural aspect to that question, but I also would like you to consider this other question, which should raise some eyebrows. What are the author's views, if they have any, in relation to a parent fixing a recording device on their child's school outfit to attempt to obtain evidence of bullying where the school doesn't accept that there has been bullying? Now, I'm just going to turn that question around to link it to an evidence question. What would be your views if before either an independent review panel or before the governing disciplinary panel, what would be your views if the parent produced that evidence of a concealed CCTV device? So there we are. Why don't we disclose the names of the children making the statements, and what would happen if the evidence was obtained by a concealed camera? Alice, you were nodding again feverishly. That means I'm going to go to you first.
So I think on the first point, why young people's names might be concealed, there's obviously got to be a balance that the teachers and staff have got to strike between the protection of those individual students, and also making sure that the person being accused knows the case against them, and there's enough information for them to be able to work out what they're being accused of, without having to necessarily breach the kind of confidentiality or whatever of the other students. Quite a lot of the time, the names are just obscured to the governors or the legal representatives, and we don't necessarily need to know the names. In my experience, sometimes the student knows the names, but it's excluded on the paperwork that you might get for an IRP or a governor's hearing. But you have to show that balance, because there will be examples where a child has been accused of a sexual offence or abusive behaviour of some kind, and the person who's made that allegation, it needs to be safeguarded. And there is useful separate guidance to the school exclusion guidance on how to manage sexual harassment between pupils, where it does talk about the need to maintain that sort of balanced level of confidentiality. But there's certainly a balance to be struck between that and making sure that the young person who's being accused knows the case against them. And any criminal lawyers here, and I'm pretty sure my other half is here, and my mum, will know that having that understanding is really important. And knowing that case against you and who's saying what, which teachers are accusing you, is going to really matter. But it will depend on the facts of what's at stake, I think. But the second question, Charlotte, what do you think? Or the first question, what do you think?
So the first question, I think most of the time when I've had pupils' names concealed, it's been on the same kind of basis that you would do it in a JR under a Section 39 order. So you both know who all the children are, and the name is just concealed on the documents from the panel, and I'm okay with that. I haven't yet had a case where I don't know who those students are, and I think I would have a problem with that, because it well, I say that I'd have a problem with that unless my client knew from the state. It was very easy to pick up from the statements who was saying what. So yeah, I mean, if parents and child are not being told who the children are and therefore cannot defend themselves as a result, then that's an issue. But if it's just a kind of GDPR paranoia, let's conceal the names from the official paperwork, I don't really have a problem with that. On the affixing the camera to the clothing, the big question in my mind is, well, what does the behaviour policy say? Because if the behaviour policy says that you can't wander around with a mobile phone or a recording device attached to you, I think that you really have to consider whether that is a sensible thing to do. I mean, there's an analogy in, there's a sort, I'm not sure that there's any law on it in the context of exclusions or education. There's some case law on it in the employment context, which is basically if you've reached a point where you have to, Lachlan and I have talked about this actually in the context of an employment case. If you have reached a point where the process is so unfair and you have absolutely no, you effectively can't trust the situation around you, and therefore you need to record because there are concrete circumstances that have given rise to a concern that the school is not complying with its duty, maybe, but I don't think there's any law on it. And if a parent does ask their child to do that, I would say they're taking a bit of a risk, even if the behaviour policy doesn't specifically prohibit it.
Yeah, so just to round that one up, if there is a behaviour policy prohibiting it, then that should affect the parent's decision. But ultimately, if concealed camera has been used to record an incident, whether that evidence should be declared inadmissible because there is a clear behaviour policy saying this shouldn't be allowed, that's a question that is going to turn on its own facts, isn't
Absolutely.
it? And yes, and the reasoning behind recording it, because if it is so clear that a particular school is absolutely blind to any suggestion of bullying and doesn't take any sufficient steps, then maybe that would lend some justification even of a breach of the behavioural policy. But hang on, I'm not the authors. Why am I answering that question? Let's just move to one question actually, which is very specific and so can be very briefly answered, and then two questions on COVID that I know Alice wants to answer. And that might be the end of matters, but we shall see. The specific question is from Michael Brotherton, and it's when directed to reconsider, so if the IRP is directed to reconsider, the guidance is quite vague. Should it be a new panel of governors or a mixture of the same panel or the old panel? What is the guidance, but also what is the author's views as to the right approach? And if the first decision was criticised due to lack of evidence, should the new panel start getting inquisitorial and request additional evidence? What do we think about that? I'm going to start with Charlotte first because I've pounced on Alice first for too long now.
I've learned not to nod enthusiastically whilst you're asking questions.
That's it. I've picked up on that.
Okay, so the guidance doesn't say anything one way or the other, and I would say in principle it's probably up to the governors to decide. I don't think you're ever going to get a decision that, you know, it's always wrong to have the same panel or it's always wrong to have a different panel. What I would say is that if you, to some extent by then, you know, from the governor's perspective, you'd have an eye on what's likely to be coming. You know, are you looking at, if you've been directed to reconsider, that might have the parents thinking about judicially reviewing the outcome if you reconsider, but you uphold the exclusion. Because obviously the IRP will have found some sort of issue with the decision that has caused it to recommend to go for reconsideration. So, depending on what you think might be coming, if there's lots of allegations of bias, you might say to yourself, well, let's have a new panel of governors look at this. Ditto if you think that there might be a discrimination claim in the pipeline or a JR claim in the pipeline, I would say probably not a bad idea if I were advising those governors, why don't you get a new panel to look at it and make sure that that new panel genuinely looks at it afresh and that they know they are empowered to make a different decision if they think that that's the right thing to do. In terms of the fresh evidence, there's nothing in the guidance to say you can't get fresh evidence. And I would say if the IRP said there wasn't any evidence on this point and the decision is flawed, the governors should be looking to do what they can to get that additional evidence.
Absolutely, yes. Alice, did you want to say anything on that? On that specific issue? I mean, certainly on the fresh evidence point, it will turn on its facts, obviously, but if the decision has been so critical on a lack of evidence, then a fresh panel not bothering to investigate that area further is going to be susceptible to a judicial review challenge, because otherwise it's, the reconsideration is meaningless. But what do you feel, Alice? Did you have anything to...
No, I agree. I think that's right. I think that the findings for the IRP will inform the governor's next steps. So it could be that they needed to do some small bits to rectify something procedurally. It could be much more substantial than that, and it's almost not worth even holding a full hearing again because it's so flawed. But I think the tricky bit for parents tends to be that they're not necessarily invited to that hearing. And in fact, in my experience, aren't invited. It's more of a, we've reflected on it and we'll have a sort of private meeting and sort of sort it out ourselves. Invariably because they are rubber stamping the IRP's decision to uphold, to not uphold the decision of the head teacher. But I think the governors are, in my experience, at that stage. They've listened to what's been said. They will, usually at that point have had some advice as well about what to do in those circumstances. And I don't think that there has been any, we didn't come across it anyway, any sort of case law on that bit failing. But I'm sure it will come. I'm sure it will come because there will be examples where new evidence comes in at that stage and further strange decisions are made or made wrongly. So it's not easy for governors, and that part of the guidance is mere paragraphs long, so I can understand the difficulties there.
Okay, Alice, you're going to answer the questions on COVID now, but I know you want to answer the question that Caroline brought about whether or not the exclusion landscape has changed because of the COVID pandemic, but also from Valerie Hero, there's a super question about do the authors know if there's an increased incidence of school exclusion following the pandemic? And she's referring specifically to pupils being placed in specific bubbles for the entire school day and perhaps understandably fights breaking out. And her experience is that she's coming across this more and more. So do we know of any increased instance of school exclusions, and how else has the COVID pandemic changed the exclusion landscape? Alice?
There's a couple of ways in which to change. The first is that school exclusion hearings are now, there's new interim regulations, not regulation, but sort of guidance to be able to hold exclusion hearings over Zoom. So you're no longer having to sit in the school library at 6 o'clock at night having to do a hearing. You can do that from the comfort of your own room as practitioners, which I think is probably quite good. It may hopefully increase advocacy availability in those sorts of hearings. So there's that sort of interim short-term thing that, long-term thing that is going to change now. But whether COVID has changed the landscape of exclusions, in the introduction to the book, we referenced a study that had been done in summer from University of Oxford saying that they were concerned about the impact of COVID on children's behaviour, children's mental health, children's well-being, from being effectively either inside for 6 months or with parents who have more limited means as a result of the pandemic, or haven't been getting the speech and language therapy that they need, or their fun and well-being has been limited in many ways. And certainly teacher friends of mine have spoken to me saying, their children are starting again from a couple of steps back. They're going back to basics in the classroom. It can be really tricky. It has been really, really hard for teachers to manage new groups of pupils who have been, in this unprecedented time off school and on their own for so long. I also know, because evidence was given yesterday by Ofsted in the inquiry, that some parents are sending their children back to residential special schools because they're fearing that the settings aren't COVID secure. And we know as practitioners that those young people who usually are at residential special schools are there because their needs are incredibly complex and often very severe. And so if parents don't feel confident that their children will be safe, then we have, you know, parents who are going to be struggling with looking after their young people at that time. Local authorities are going to want to keep that oversight there. It is making things more tricky for parents and young people and schools in managing that kind of behaviour. Have I had school exclusion cases this term? Yes. I think all of us have, for all kinds of different reasons. I think that in arguments about exclusion, you can say, well, you know, the pandemic's had an impact, and it I think is something important to mention in proportionality of those decisions. Yes, I can see why. I think Valerie here said, you know, there will be examples where the bubbles are going to create problems for some young people, and those duties to make reasonable adjustments haven't gone away. So the, you know, Equality Act framework is still going to be necessary to think about. But of course, the reasonableness of those adjustments is going to be in a different, seen through a different lens at the moment, and that is going to be an important thing as well to think about. But yeah, I don't think we can stress more the impact of COVID on the education system. I think it is making things immeasurably difficult for schools and young people.
Sure. I notice we've got a contribution from Aoife Thompson at BLAM UK. That's a non-profit organisation for the Black community in the UK. That they have seen a case of a young person excluded for not wearing a face mask. And obviously that's an issue that may or may not be susceptible to challenge. Charlotte, did you have anything to contribute on that, or shall we go to the next question?
I agree with everything that Alice has said. Obviously, normally I'd rephrase it at length, but
but we're coming. Yes, we're certainly overstaying our welcome slightly, but I do know, Charlotte, you want to answer Nigel Pugh's question about the conflict that the Governor's Disciplinary Panel will have between supporting the head teacher and being seen to support the head teacher, and of course caring for the child. And the suggestion is the conflict is one way and caring for the child is not a priority. Charlotte, what would you like to say about that?
Well, there is a statistic on this that unfortunately tells its own story. Alice will remind me of the precise figure, but it's something like 95% of appeals to governors uphold the head teacher's exclusion. And that contrasts, unfortunately, not desperately favourably with the statistics in terms of parental success before IRPs. I think that the pressure that governors are under in terms of supporting the head teacher is considerable. I think that it is, to some extent, I don't think that it is a conscious, we're looking at this exclusion and we think it's unjustified, but we're going to support it anyway because it's the head teacher. I think it is more that they work with the head teacher, they have a relationship of trust with the head teacher, and they are just very, very inclined to accept that the head teacher's decision is probably right. I think it is difficult. The dynamic between governors and head teachers can be quite interesting because obviously the governors effectively line manage the head teacher and the head teacher is accountable to them. But at the same time, the head teacher has a position of immense power, responsibility, and to some extent it's quite a charismatic role. A good head teacher has a lot of charisma, and it's not just the pupils who will feel that, it is the adults who work with the head teacher as well, and the governors are no exception, especially if you have a concern that if a particular head teacher leaves or feels unsupported, what's that going to do in terms of, you know, the trust of the parents, which is often very much invested in how they feel about the head teacher. So it's a really complicated situation, but as I say, there is a statistic on this and it does tell its own story, I think.
Excellent. Thank you for that. One final question from Kevin McManaman that I know you may very well have a view on, because you do have a chapter dealing with the differences between independent schools and maintained schools, but this is about independent schools. Do you have a view on whether the principles of natural justice apply to exclusions in independent schools? Could it be argued as an implied contractual term? Says Kevin, and sadly, Alice, you nodded away there, so that to me suggests that that you would.
so not me.
I do have a view on this, if that helps.
Okay, Charlotte, shall we hear from you first then?
Yeah, so I think firstly, you've always got Section 49 of the Consumer Rights Act, which implies into all contracts for the provision of education a requirement to deliver the services contracted for, in this case, the provision of education, with reasonable care and skill. So there is always the potential to argue that kind of thing in the context of Section 49. There may be some express terms in the contract about how exclusions or removals are to be dealt with, or expulsions, because independent schools still tend to call them expulsions rather than exclusions. And there normally are two separate options. There's expulsion, which is your child has behaved unacceptably and we are telling you that they can't come back. But there's also a second option, which is a removal, which is your child is not doing brilliantly for a number of reasons, and we are going to ask you to take them away at the end of term, which is a slightly different thing. So there aren't really, natural justice is kind of a public law concept to some extent, and we know that contracts for the provision of education with independent schools, including exclusion decisions, are overwhelmingly a matter of private law contracts rather than public law. However, there is some authority, I think, I can't remember the exact name of the case, there's some authority for the proposition that a head teacher of an independent school has to investigate before excluding, at least for a disciplinary or behavioural offence, and that they should do so in line with the principles of natural justice. But I think that you would conceptualise that as falling within reasonable care and skill.
Excellent. Alice, did you want to add anything to that?
I was going to say that there is some useful case law from the kind of commercial contract law world about things like golf clubs, other sorts of settings where principles of natural justice are explored. I'll pop a case in there, the chat, which was about a golf club once I find it, but it does make that point that you can apply a requirement to act in principle with the requirements of natural justice to a contract breach issue. Whether that would be that effective, I don't think you could rely on that alone. It would probably be much better to go to something a bit more juicy in your breach of contract claim, but it's not something that I would pop it in if you want. Kevin, try it out.
Excellent. Right, we have exhausted all of our participants' questions. I'm just going to ask one of those final questions to sort of slightly light-hearted and introduce some levity before I close off our meeting. And it's very brief answers required from both of you. And I'm going to start with you, Charlotte, first. Simple, either single word or short phrase answer. What have you particularly enjoyed about writing this book, and what have you hated, if anything, about writing this book? What have you enjoyed, and what have you found more challenging? Shall we put it like that?
It's the first book I've written. I loved writing it with Alice. Alice is awesome. I loved the subject matter. I initially found it very difficult to know where to start. There was an awful lot of staring at a blank page and writing 2 sentences and then swearing and deleting it all. But once I got started and worked out that you know how to structure it, it was great.
Alice.
Footnoting wasn't very fun. I didn't like that bit.
You are allowed to start with the fun bits.
Yeah, no, get that out of the way. No, the fun bit, it was really, really nice to write something that I'm really passionate about, I have to say, and to actually feel like I knew what I was talking about, which was rare at the bar. If you've ever had imposter syndrome at the bar, it's a really nice feeling to think, okay, I actually have something I can valuably say here, and to put that in writing. So it was a really nice feeling, and I feel quite proud of it.
Excellent. And you are not obliged to reciprocate that one
Charlotte,
of the fun bits was working with Charlotte. Ah, excellent. You got there.
So
Yes.
obvious that you didn't even say so. So obvious.
Can I say to both of you, thank you, because actually not only have you written such a brilliant, easy read suggests it's dumbed down, but I know it isn't dumbed down because, well, I've read at least the first chapter and it's far from dumbed down, but it is accessible, and that is so important for all our clients, whichever side of the exclusion decision they come from. But thank you also, both of you, for doing more than that, because tonight what you've done is you've answered some pretty searching questions, actually, surrounding the topic that go beyond just merely presenting this book and launching your book. So thank you, both of you. But the thanks don't stop there, because I also would like to thank all our participants. They've whittled down to just 46, but that's entirely understandable given that we've gone over our schedule that we anticipated for this meeting. I do particularly want to thank the 46 for staying with us. I hope you've enjoyed it. One of the things that I always say at the end of meetings such as this, it is actually precisely for you, the audience, that we do these things. And of course, we cannot survive without your contributions. And some of you have asked some great questions, and some of you have provided some lovely contributions in the chat panel as well. Thank you, all of you, for that. And thank you for attending. No doubt, if you have more burning questions, you will be, you know the links, you know where we are. We're readily available. We have a superb PR and marketing team that's put us right on top of the search engine optimization bracket. So we're not difficult to find in any event, but most of you, I know us already. Thank you all for attending, and thank you, Charlotte and Alice, and congratulations.
And
well
thank you, Lachlan, for hosting this, because
so
otherwise I just burbled endlessly.
Thank you, David.
And what we're now going to do is stare into the screen until we are removed by, no doubt, Lisa, and the session ends.